Hello, good afternoon, good evening. Welcome to the SAPI IP Business Talks. We have end of February. It's now the 21st of February 2024. It's Wednesday, obviously, so typically we try to make it on Wednesday. And we are in Europe, in Turkey, and we are together with Erdem Kaya, and he will introduce himself for you, for the audience, for the moment, just to make sure that you understand the format. So it's live, which means you have the opportunity to ask questions, to give your comments right under the post. We will see that here in the studio, and when it is anyhow possible, I will pick it up and ask Adam your questions, whichever you have, as long as it fits in general to our topic for today. And we want today talk about startups, software patents, entrepreneurship. So that is our field. And Adam is quite active also in I3PM, International Institute for Intellectual Property Management. And there he's committee chair. And so you are always invited to contact him around these topics. He's an expert with so many years of experience. He will explain us that. And so first of all, feel invited to ask your comments, to ask your questions, to give us comments. And we are happy to talk about that. So now, Adam, this is your stage. Please tell us a little bit. Typically, all of my guests, the first question is, what are you doing? And basically, how did you came into this, very specific and for some people very, very nerdy field of IP? So what you're doing there and how did you came in?
Okay. First of all, thank you, Alexander, for inviting me to this webinar, and good evening to everyone watching, actually. And I am, on the other hand, I am very happy to be part of I3PM community, and I hope we do much thing in the close future. So let me explain and introduce myself. I am actually 45 years old, a bit old man, older than you.
I don't believe so.
You look younger than me. So and I'm electronics engineer, studying electronics in Turkey, and became patent attorney 23 years ago. So of course, during my study, I was not aware of the IP rights actually, but just at the end of my university time, I just there was a professor and he advised me to actually go deep into this field because I didn't want to be a core electronics engineer, to be honest. So I was lucky. If I was an engineer, core electronics engineer, I would not succeed that much, to be honest. So I'm happy with my profession. And I just became, and then I attended the patent attorney exam in Turkey and became a patent attorney. And as I said, for the 23 years, I've been in this profession. So what we are doing is that now I am running a well-known IP firm in Turkey. We are about more than 50 IP professionals, having, electronics engineer, mechanic engineers, and many technical, many patent attorneys from technical and science backgrounds and attorneys at law. And we are doing all type of IP, from filing to litigation, but especially for the last 5 years, I mostly focused on the strategic IP management because as you lead this area, actually, this is becoming very important topic because, because of the economic, struggles in the world, people and companies, and including startups, want to make most of their IP rights. So IP management is quite important. So since I am actually electronics engineer, this is why I mostly focus on computer implemented inventions during my profession. Of course, as I said, we have mechanic engineers or chemistry engineers, everything, but mostly I try to focus on CII, what we call computer implemented inventions, during my profession. On the other hand, I am angel investor, so this is also interesting because usually we don't see too much patent attorneys acting as an angel investor, but I am one of them. So in Turkey, I am very active actually in this field. Almost every week we met with startups. We listen to them, we listen their pitch decks, and uh, sometimes decide to invest. Sometimes we don't invest. So this is very also interesting for me, because by doing so, I am now getting the marketing view, financial view, strategic view. To So I have a chance to combine these views with the IP aspects. So this is very valuable actually, because it is IP is, as you always say, IP is a very strategic instrument and a very valuable instrument. So you should know about the its financial, effects, marketing effects, strategic effects to your organization or to economy. I think the introduction. I don't want to talk too much about myself, and I think it's okay
No,
if you have a
it's very
question.
interesting. I didn't know that you act as an angel investor,
Yes.
because I think it makes for me, it makes totally sense when you understand the technology, when you understand the economics, the markets, when you're interested in that, and when you can really help companies with their most important assets. So it makes absolutely sense. But I assume that you do not invest in companies for which you are also the patent attorney. That
You
wouldn't
are,
work, right?
yes. Usually, actually, for example, I invested four, startups so far, but three of them were my clients actually, because
Ah,
they are
yeah,
doing well. Actually, I have data. I know what they are doing. I know their technology and their potential actually. So it makes me easier to invest them. But
absolutely.
of
Yeah,
course, we have an angel investor network in Turkey, just like in any other countries. We have many angel investor networks, and I belong to one of them. And of course, I personally sometimes invest. Sometimes we invest as a network. Then they do ask my, of course, views, but I try to be objective. Actually,
at least,
this
Adam, for
that's it.
me, at least that sounds that you are one of these chefs who is eating their own meal. So so what you cook, yeah. So you really invest in companies for which you made the IP. I mean, that's a great thing.
Yes. Yes. Sometimes also sometimes have a stock option. Let's say we met a startup. They have a very good technology, very good team, very good marketing potential, but they don't have too much budget to spend on IP matters. But without IP, they cannot. Survive. They cannot compete. So sometimes we just take over their IP budget. We pay even official fees for them, and we get some small stock options, and it really works well.
Yeah,
And
get you.
yeah, it works. Why not?
Very interesting.
Everybody's happy, so no problem.
Yeah, makes absolutely
Yeah.
sense. Yeah.
For example, I just invested one startup, and now they have more than 40 patents, and almost half of them are worldwide patents. And now the inventor were ranked among top 100 inventors in the world. So
Wow.
it really works sometimes. Because you smell the technology, as a patent attorney, you smell the technology and its potential. Also, if you have a marketing view, if you combine this with your marketing view, it really works well. Final words. Actually, we also I invest on a software. This software matching is matching investors with inventors, and it
Wow.
has capability to make financial analysis. I mean, you can prepare your pitch deck via this software, and it really works well. And we as 3 months ago, a big venture capital invested on this software as well. So uh, it's always good to use your network to create more
Yeah.
synergy from your profession.
Got you. Got you. So let's start with our talk about software patents. So I would like to start from a terminology, because I have the feeling that there is a lot of confusion out there. And I mean, we have software. Okay, so we should talk about a definition of software, and then we have something which is called software patent. And just to give a starting point, I a week ago I read a paper from an official German states-owned supporting scheme in the southwest in Baden-Württemberg, and they gave the recommendation. They said something like a software patent cannot exist because software cannot be patented. So, and to be honest, I think that is not really helpful what they write there. And then, so we have software patents, and then we have something which you called a computer implemented invention, CII. So I think these three things we should talk a little bit about. So first of all, how would you define software as general? What is that?
Of course, there is some academic definitions, just like software is a set of instructions, data or programs used to operate computers and execute specific tasks. It's known definition of what software is. But in general terms, as you mentioned, there is a saying, software cannot be patented. But this is just the confusion is that if you read the patent, sometimes some startups wants to read the patent laws like European Patent Convention or any national regulation. They see wording programs as such. It is written programs as such. This causes problem usually because when they see the wording programs as such, they simply understand that software cannot be patented because software is a program, but it is not true. Software is more generic term. What programs means the only program codes like written in C language or maybe Python language or PHP language whatsoever is.
And the interesting question is, who want to patent that? Nobody. I mean, that doesn't make any sense. To patent code. I mean, when you say software is a big term. Yeah. So we have architecture, we have functionality, we have routines, we have algorithms, we have data, we have interfaces, input-output interfaces, human-machine interfaces. So it's a big documentation. So it's a big thing, first of all. And it's a big thing simply because it is the non-physical part of a computer. That's it. When you have a computer, you wouldn't need any software per se. You could put it all into hardware. So like a pocket calculator, when you want to be very fast. I mean, I'm talking to an electrical engineer, so you know that, of course. So, and when you say, okay, I don't want to be that fast, but I want to be flexible. I want to make it cheaper to change things. So then I take this part out and I call this part, which I put out of the hardware, I call it software.
Yes.
And that's it. I mean, it's just a part of a computer, which is flexible, which makes the computer doing something. And that's it. And now comes the patent law. And this is something completely different. So the patent law don't care, so to speak, the patent law don't care about computer science or any science. This is simply not a part of the patent law. The patent law says when you make something technical, when you solve a technical problem with a technical solution, you're welcome.
That's it. Yes, that's it. It doesn't matter whether it's a software or not.
And can you explain us a little bit what this and there comes this technicality in it in this discussion, which is totally strange for as you said, startups, software guys. I said, why they are so focused, these IP guys so focused on this technicality thing. Could you explain that, where that comes from?
Yes, of course. First of all, as I mentioned, the program codes. Maybe we should talk a bit about the copyright as well. So we have a copyright protection for software codes, program codes, but it's very narrow protection, and it's simply what the exact code, and it can be designed around, it can be move around very easily. When it comes to the software, yes, there is a technicality issue. Usually, especially in Europe, including in Turkey, in laws and regulation, the what is technical is not defined, not to limit the future developments, but usually what is not technical is tried to be defined. So it is easy. So we usually, as a patent attorney, we refrain from define what technical is, because it may limit the future. Let's say maybe 20 years ago, maybe there wasn't nothing. We don't know about quantum computing or quantum cryptography or maybe even AI. But now there are new area, and maybe dozens or thousands of inventions, thousands of patent applications are being filed in this area. So what is not technical? Usually, I first define what is not technical. For example, if the results are subjective, and if the results are only understood by mentally by humans, usually these are not technical, because human mind are so subjective. Because when you feel something, you can feel different than me. So we call it mental acts. Let's give you some examples, and I don't want to be too academic actually. For example, usually many administrative issues are not technical. Let's say human resource management, IP management, or maybe workflows, or the insurance calculations, incentive calculations, fintech solutions. These are all usually seen as a non-technical area. Also, let's say amusements. For example, I invented the repost feature in Instagram. This is a very good feature. It has a huge marketing potential, but when I ask myself what technical problem it solves nothing usually. So usually I try to define what is not technical. And by the way, there is a political reason for that as well, because as we all know, US in US or the softwares, US are more open to patent softwares than Europe, including Turkey, because the software market is very developed field in that in US. But when it comes to Europe or Turkey, we are not in that level. So usually, as a governmental policy, they don't want to broaden the scope of the protection for the softwares, because then the competition will be hard for European companies.
Even harder, let's say.
Exactly, even harder. So this is the reason, and maybe I can give for some more example from my professional experiences about.
For the moment, we have this third term, computer implemented invention.
Yeah.
And maybe this is, so to speak, the fusion between software and technicality. And for that, the IP system, especially the European Patent Office, developed that term to make clear that this is software. And this software has a technical effect, and insofar it should be patentable as far as it fulfills all the other requisites. And but obviously, I don't know what your experience is, but so my experience is that when you really use the term and talk with, let's say, startups or software guys, so they stare at you and say, "What is that? I don't understand that." So how do you deal with that?
Yeah, actually, I usually, again, refrain from using the word of computer implemented inventions when talking to startups, because they don't understand. If you give too many details, things get more complex. So we should communicate with the startups as plain as possible. So I usually say, yes, there is a saying, if you want to have more information about software patents, you should Google the wording computer implemented inventions. Then you can find more targeted results. That's it. That's it. Because you are not a patent attorney, startups. So usually, but it is a good wording, technical good wording for reaching correct legal information about software patents. That's it. But and also what it means for me, it's just the combination with software with hardware. That's it. Because as we all know, software as such cannot be patented. It should run on a hardware, but usually it's how it is actually. So every software runs in a hardware, but but when you drafting your patent application, if you don't use any hardware wording in your patent, it will be directly rejected because you cannot patent software. It must run at hardware, but every software runs at least on a computer or in a calculator on a specific and
Exactly.
specific designed hardware. So there is no problem at all in that
Yeah,
field.
I mean that is what typically is said in the software patent. So that it is a algorithm or a software, and that runs on a typical hardware, and that's it. I mean, that is a prerequisite. You will write it in, and you have it. So it is
Exactly.
it is it is also nothing excluded, okay? Because yeah, and you have the software claim at the European Patent Office also. I mean, but let's come to a bigger picture. So um, obviously today more and more companies, so you can say every company or most of all companies deal anyhow with software. So even when it is a machine manufacturer or trading company or whatever, all have software in it, and lots of them make also innovations with software. And so obviously they try to protect their inventions. And what would you say? What is the big picture? What are the trends at the moment around patenting software-based solutions?
First of all, as you mentioned, in nowadays every product has a software. So and when we see the statistic, we will see that IT related inventions at the top, even higher than the number of filings in chemistry. So this field is very active, as we all know. So and the trends, when of course I mostly deal with the inventions in Turkey, but Turkey usually follows, Europe, developments in Europe. So every year we're having more requests from startups for their software patents. But usually, as I said, since there is a specific technicality character so usually we need to, we have to say that this cannot be patented because many software companies usually dealing with game or fintech or maybe some SaaS solutions, and usually all of them usually they don't have any they don't solve any technical problems. But when it comes to embedded, software, just which can be used in machinery or which can be used in autonomous driving or whatsoever, then these can be, of course, patented. And also there is a field AI. AI creates many opportunities. Usually, of course, core AI, models cannot be patented because they are mathematical models.
Yeah.
But if you solve a technical problem with use of AI, an AI model, then of course these specific application of AI can be patented. And
I mean, what you say is, I mean, on the one hand, it is extremely fascinating. On the other hand, it is trivial, okay? Because the patent system is for technology, technical solutions for technical problems. And when your model is an AI, so who cares? I mean, it is basically anyhow code. It is software, and it is special software which works in a different way than a classical compared to a classical input-output relation in software, but that's it. I mean, it's not that kind of rule-based. It's a different way how the rules are made. As long as you discover a technical teaching, where's the problem? And I mean, this is the next thing, yeah. So discovering a technical teaching and computer implemented invention. I think that is the whole terminology which the IP system has developed. And by the way, I mean including technicality. Yeah, this is simply not helpful when we talk with entrepreneurs, with software guys, with startups. So I think we simply should avoid it and discuss with them in a terminology which they understand. Because when you tell them it has to be technical, so what I mean, no. no reaction in their faces, in their brains, because simply they are not trained in this kind of art, obviously. I mean, what do you think? What should an entrepreneur or a startup? What do you think? What should they know, or should they know anything about it? So does it make sense to to teach them, or how can we help the companies to be more? Yeah, at the moment I have the feeling that they are completely shy. They stay away of the patent system, say, oh, software, computer code, program code cannot be patented, so I stay away from it. And this is obviously not a good thing. So they should come and they should ask for protection. So what do you think? What should we communicate at the end
Yes.
to these very important participants of our economy, to invite them to test, to work with the IP system?
Yeah, this is good question. And you actually, when I met with a startup having, I mean, invention with some software part, actually, I first of all I tried to convince them that you need IP protection to compete with, I mean, to stay competitive. So we should find solutions to protect your IP, your invention somehow, whether it is software or not. So first of all, such guys should be convinced on that actually. Otherwise, if they believe that they can survive without IP protection, then it is not easy to, I mean, to advance, to move forward. So this is very important because, startups, usually they don't have any resources, financial resources, or maybe they don't have any connections. They only have their inventions or IP. And first of all, I try to convince them of the importance of IP. Then when we talk about software, usually for example, I ask them to explain their business model. I usually call them as a roof. So let's say I have an invention and I have a software. This software chooses correct candidates for a specific position in an organization, let's say. And this really works well, and they have some clients. Maybe they about to get some investment. So I say this is a roof. So, but this roof should stand on a columns. There are technical columns and non-technical columns to keep this roof, standing. If any of these columns is broken, then there is a risk of, breaking down. So I say, as a patent attorney, usually good patent attorneys teach inventors what their invention is. This is very important. We are very good at catching the essence of the invention. What is the essence of the invention? So maybe even many inventors cannot explain what they invent. So we use some psychological, questionnaire tactics to reveal the essence of the invention from their minds by asking many questions. So these are.
Oh,
So
Erdem,
I say,
I like so
yes.
much what you're saying. I like so much what you're saying, because this is, I mean, what you're doing. We call it IP design. Okay, we say it is not so that the inventor knows the invention and that the patent attorney has nothing to do with the invention and just get it from the inventor and write it down as it is. That is rubbish. It is a joint birth, giving birth to the invention together. And this is so interesting that you're saying that. And to the audience, I had not anyhow script that for Adam to say that. Yeah, so that was his own voice. just to mention. No, I mean, this is exactly how it happens, and that makes it that is, another discussion, obviously. So how we create IP and how we create inventions, and obviously this is not just something which comes in from an invention disclosure and everything is disclosed and you just have to write down. That's a fiction which comes from the patent system, and it would be maybe easier for the patent system when this is the truth, but it is not in practice what happens. I have a question from Maria, and like always, she's asking very good question. And she says that I mentioned that I have the experience of that software guys stay away from the patent system for lots of reasons. So in terms of they don't like patents and they like open source and they think that open source has nothing to do with IP, which is obviously rubbish, but okay. And so what she's asking is, what do you think? How high is the level of awareness about IP, especially patents, for software, let's say startups? Because my experience is that they fall out of the blue. They are completely shocked when I show them software as a service patents, infrastructure as a service patents, whatever. I show them simply the patents, granted European patents. I say, don't come up and say this can't be patented, because the problem is when you think software cannot be patented, then you are shocked which kind of patents are out there. You think they cannot exist, and then you have a very serious freedom to operate issue, maybe.
Yeah.
So, what is your experience about the level of awareness there?
Yeah, it's a good question as well. Thank you. Yes, for all startups, actually, IP awareness is not that high because usually they don't prioritize IP rights until they face with some problems actually, usually. But this is important. So in Turkey is the same. But as I said, communication is very important. I mean, if you teach them the importance of IP in a plain and clear languages, it really works well. For example, in what I am doing, we always organize trainings. For example, I maybe delivered more than 100 trainings about computer implemented inventions, and I try to explain the matter as easy as simple as possible. Then it raises their awareness, and there is a saying, culture eats strategy at breakfast. So culture setting is important than everything. So what we should do is culture setting. So in Turkey and even in Europe, there is I mean I heard this wording, this phrase thousands of times. Softwares cannot be patented. Softwares cannot be patented. I say this is not true. As I said, there is a roof. Your business is roof. Here's a columns. Yes, for non-technical columns, we may not be patent the non-technical columns, but as a good patent attorney, I can reveal from your software some technical columns, and we can patent it. And usually, this technical columns usually provides, a good advantages. And if you protect this column, this core, then the rest is not important if you protect the core. Let's say, as in my previous example, you are having a software electing correct candidates for a job, and yes, you have a program code. This cannot be patented. Maybe you have some, algorithm for electing, let's say, churn algorithms, similar to the churn algorithm, a ranking algorithm. It cannot be patented. But maybe you may have some data structure. This data structure reveals the solution maybe faster than the usual, architectures. Or maybe you can use computer resources. You can use lower computer resources, and it can be patented as well. So we should find some technical columns. But this is not only for protecting inventions, also for PR reason. Because if you say that I patented my software, usually it works well. Investors, clients, everybody say that this guy patented its software and it really works well. So maybe he spent, let's say, $1,000 or $10,000 for getting patent protection, but maybe the outcome will be 10 times or 100 times more than what he spent.
So what you say is, from an investor perspective, we should foster this misunderstanding that software cannot be patented, and that makes the software patents extremely valuable.
Yes, by the way, you don't have to get a certificate at the end, to be honest. There is a thing, I think the Bosch Group says this: 20 patents in a day keep competitors away. I like this saying because the patents not only for protecting your innovation, also to disturbing your competitors, to
absolutely
keep your competitors away from your field of activity. So if sometimes you file a patent application, but maybe the chance of success is very low. But it takes at least 3 or 4 years to get the result. And in the meantime, you will, disturb your competitors. They cannot be sure whether you will get a patent or not. And if you gain 6 months or 1 year to market penetration, it works well.
Another question which came up is so obviously we have an awareness issue about patents and software, yeah, in startups, in digital startups. So that is for sure. On the other hand, something different is with let's say trade secrets.
Yeah.
So trade secrets are tricky because I mean, just for the audience who are not in this game, so you have to make sure that they are secret. You have to be able to show that you keep them secret and so on. So it's an organizational issue, and to a certain extent I would say it is much more tricky and difficult to really keep trade secrets, so maintenance trade secrets, compared to maintenance a patent. But on the one hand, what is your experience? So do companies, startups, entrepreneurs have an understanding of the difference and of the effort? And what is your recommendation when it comes to, maybe that is a decision to a certain extent, it are completely different mechanisms for completely different reasons, but let us assume that there is a decision. So what would be your recommendation in such a situation?
This is a very good question as well. It sometimes happens in also some productions, methods, or similar inventions as well. So first of all, I have to say that when we are drafting patent applications, we usually refrain from giving trade secrets. We make them more generic. So even, for example, when it comes to software patents, we don't even give one line of program codes. We just explain how algorithm works with some block schemes. That's it. We don't give anything detailed. So it is the startup should feel comfortable that your secret information will not be published when we file patent applications. But of course, if the reverse engineering is possible, then you have to include this information in your patent application as well, because when you market your product, your competitors can easily be revealed all details by doing reverse engineering. But the reverse engineering is not possible, then we should discuss about to file a patent or not, to manage the trade secrets as well.
Okay.
As a patent attorney, I always advise to file a patent application,
Absolutely.
but without giving too much details.
Exactly. You don't have to take that. So now comes the next guy in and say, yeah, but you have to disclose the technical teaching, da 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 da. Yes, of course, you have always to fulfill. So for all my IP experts out there, yes, you have always to fulfill the regulations of the different offices, especially here the European Patent Office. But when you are in these kind of regulations, you shouldn't give too much details,
yes.
and that is not that tricky to a certain extent. So my recommendation is always, I got your reverse engineering approach. I typically try to flip to the other side and say, okay, look, when I'm telling you, when we talk about business models, use cases, customer journeys, when we talk about things which per se can third parties see, simply because otherwise you cannot make any business, because they see what you're doing, you should protect it. Yeah. And not the nitty gritty details inside of your mechanics. Nobody's interested about that. It's what everybody can see. And I mean, it's the same thing as you says, reverse engineering. Yeah. But I try to make it as simple as possible for the people out there and say, as long as a third party can see what you're doing, try to protect it.
Exactly.
So, because it's done when you are online.
There is no otherwise you cannot compete. That's it. So there is a wording, we call it forward patenting. This is very, a good wording, because we should protect features directly understood and sensed by your customers.
Yeah, exactly.
Maybe
It's a little bit, we could, unfortunately, nobody knows design right, and so it doesn't help when you say it's the same as with the design rights. As soon as you can see it, you should protect it, and otherwise you cannot protect it with design rights. But that's just a joke in for IP nerds.
but yes,
Adam, another question is the following. So Sweden had that question. It's a bit tricky. So I would like start with the first question, then I have a second one. So first, can you explain in simple terms what is basically the current approach of the EPO when it is about patenting computer implemented invention? So we have this two hurdle thing, and can you explain it a little bit so in simple terms that everybody understand it in 2 minutes maybe?
yeah. As I said, I mean, for me, of course I see many decisions from EPO about the software. I mean, computer implement inventions. We say software patents. I mean, how can I say? EPO should change actually their look to software patents because they are so solid. They are so strict in technicality issue. So to be honest, in Europe, it is not easy to get a strong patent protection for software patents, including in Turkey. This is the problematic issue, but I mean they should maybe broaden their risk. I don't know. Of course it takes maybe 10 years. I don't know, but I don't know. But it is very tough issue. Sometimes it may be
But,
very tough.
but at the same
Not,
time, you said that wouldn't be good for the European industry.
yes, yes. I don't know. I don't understand what the underlying reason, but it is the same in Turkey. But there are strict rules. There are strict. Case law about technicality issues. For example, just like simulations, we have some. Recently having these decisions about some simulation related, inventions, and
You mean
usually if you,
G119 or
yes,
which?
exactly, but it should. I don't know, but it should be patented because it's a very good invention, and usually, so when it comes to EPO, as I said, if you solve a technical problem, it is so easy. It's simple. But if you don't solve, let's say, I usually try to explain to startup with giving some example. If you're inventing something administrative, probably you will have some troubles when getting patent from EPO. Just business models, human resource management, SaaS models, some e-traits, algorithms, or maybe evaluation, valuation algorithm whatsoever. You have a problem when getting patent from EPO. For
Yeah, but
example, if you're in the fintech field, it's hard.
on the
But if
other
you're in
hand,
payment tech, it's okay.
Adam, on the other hand,
Yeah,
I
sorry.
would say especially software as a service. So it is about giving third parties access to technological resources. So you have to organize the access priorities. You have fault, fraud, fault, or whatever handlings. So I would say there's a lot of technology. I mean, I don't know this concrete case, but maybe this startup is simply looking in the wrong direction when it comes to software patents.
Yeah. To be honest, again, they need to be honest. We call it for patent attorneys are mirrors. You look at the mirrors to see who we are and how you look at it. So if you are a good mirrors, then it works well. As I said, we filed hundreds of software related patent applications every year. So software can be patented, but you need a good patent attorney to so that they can reveal the features that can be patented. This is important. If you
Yeah,
think
exactly.
yourself, you usually end up with say, I cannot patent anything,
Yeah,
and
yeah.
you
That I
don't
mean,
want to.
that is a wonderful final word. Sorry, we're running out of time. I could talk with you hours.
Yeah.
That is a wonderful final word. That it really takes a good partner, Tony, which who has a certain experience in that field. So not everybody is, and it shouldn't be done by everybody, and it must be not be done by everybody. And so choose your partner, Tony, right. Sveta, we had not the time to talk about the difference between European patent law and Turkish patent law about computer implemented inventions, but I promise you, Erdem will be in the after show party on LinkedIn, and he will answer to your questions. So when you have still questions,
Sure.
we are available. Especially our expert Erdem can tell you and give you some advices on LinkedIn about your question. Erdem, thank you very much. I enjoyed that so much that you were here, and I give you a secret. Which you cannot find on LinkedIn. In 6 weeks, I will be 10 years older than you. So
Really?
enjoy your evening.
Okay. Thank you. Have a nice evening, and thank you for